In Judge Simpson's courtroom, a young law student from Seattle faces his first Michigan hearing. The judge, amused but firm, questions him about his background and his loyalty after his college team beat the judge's own. The exchange is light-hearted, but behind the humor lies a lesson. In this courtroom, respect and readiness go hand in hand.
On behalf of our client, Mr.
Boy,
Fan.
that's a long intro. Go.
Apologies, but
Go on.
there is more.
There's more? Okay, go for it. I got all morning.
We are requesting permission to practice in your court under Michigan Court Rule 8.120 with the supervision of Miss Allen.
Have you been before me?
I have not, Your Honor.
I didn't think so. Where are you from?
I'm from Seattle, Washington, Your Honor.
Oh, it's really damp there. It's like rain, just rain. It's just, I don't know. Anyway, so where'd you go to undergrad?
The University of Washington in Seattle, Your Honor.
Oh, is that different? That's different than UW.
No, that is UW, Your Honor.
Is it? They're in Seattle?
Yes, North Seattle.
You understand that they beat my Maryland Terrapins, so you're in trouble. You should have said that was not the school.
I mean, I don't know if you know this, Your Honor, but I did switch sides after we lost the national championship. So I'm here in Michigan now. That's where my allegiance.
You didn't belong in the game. Listen. Anyway, I don't even know why you were there, but that's okay. All right. So are you from Washington?
Yes, Your Honor.
All right. So you went to UW and now you're at Michigan.
Yes, Your Honor.
Okay, I'll let it pass. Permission to practice is granted. Go ahead. Good morning, Miss Sullivan. No.
Good morning, Judge.
All right. What are we doing on this case?
Hi, good morning, Your Honor. This is a case for a termination of tenancy stemming from multiple breaches of a residential lease agreement. We're seeking, basically going to be asking the court for a trial date for us to seek a judgment of possession. I will note, Judge, that I did receive, it looks like, an answer in affirmative defenses from defendants, as well as a demand for jury, as well as a motion for summary disposition. And so I think just looking for a scheduling order, Your Honor, to address all those issues.
Well, that's not entirely how we would do it. I guess the summary.
The student attorney argues that the landlord accepted rent long after a move-out notice proof. He says that the tenancy still existed, but the plaintiff's lawyer pushes back, insisting it was no misunderstanding, just a breach. Judge Simpson listens carefully, weighing both sides, because in housing court, even small details decide who stays and who goes.
Our exhibits, the first of which being bank statements showing about 3 months worth of rent acceptance after the August 22nd move-out date specified on the notice to quit. The second exhibit we have is a signed HUD recertification signed by Mr. Fan and the building manager, Mr. Christopher Writings, if I'm pronouncing that correctly. That's from September 30th. And lastly, we have a notice of processing of that HUD recertification and a subsequent rent increase that was sent to Mr. Fan. That rent increase was actually set to take place tomorrow, all of which occurred, several months after the expiration of the notice to quit, and aligned pretty neatly with the dictates of Park Forest there. And I will note just briefly for the court that Mr. Fan is with us here on Zoom. However, he has recently suffered a stroke, as a result of which his blood pressure consistently sort of reaches dangerous highs in stressful situations. So I just wanted to flag that for the court in case he does become unavailable momentarily. But in any event, for the sake of his health and on the basis of those pretty straightforward notice violations, yes, we are asking that you grant our motion to dismiss today.
Your Honor,
Yes, go ahead.
If I may address that, the Park Forest case doesn't apply here. This is not a non-payment of rent termination of tenancy. This is a termination of tenancy as it relates to multiple violations of, unauthorized destruction of process or unauthorized modifications of premises, destruction of property, aggressive behavior, all other types of.
Yeah, but that's fine, except that the basic premise behind Park Forest isn't necessarily that it's a non-payment of rent case. The basic premise is that the landlord has done things that have led the tenant to believe that the tenancy continues, despite what their complaints may be, whether it be non-payment or whether it be termination.
Understood, Your Honor. Understood, Your Honor.
So,
if I may, Judge.
yeah, go ahead.
We have been engaged with Mr. Phan's prior counsel in negotiations of a settlement with respect to this issue. They have been on notice that we have been postponing filing the lawsuit as we engaged in those discussions. It wasn't a situation in the Park Forest where the tenant was led to believe that the notice to quit was waived. Here, at all times, prior counsel and Mr. Phan was aware that we were continuing to enforce the notice to quit, and we were engaged in settlement discussions as a result, as it relates to that. As recent as end of September, Mr. Phan's prior counsel did identify that they could not reach an amicable resolution and suggested that we go ahead and file the complaint at that time. So this isn't a situation where Mr. Phan was led to believe that acceptance of rent or other actions waive that termination of tenancy notice. In fact, at all
I think that's going to be a factual determination. I don't know that one that I can make just on the thing. I understand what you may be saying, and I'm not sure. Well, I won't go into that. All right. So first thing is I'll need an answer to the motion for summary disposition. How much time do you need to do that, counsel?
Let me look. Sorry, Judge, just looking at my schedule. I'm out of town next week. Is it possible?
Then we'll do it then. No, go ahead.
Yeah, no. Is it possible to? Do you need an answer date or a hearing date?
Yeah. Well, I just need. How much time are you going to need to file an answer, and then I can give you a hearing date?
If I could file an answer by the 14th, that would be sufficient time for me, Your Honor.
All right. So I'll indicate answer to motion by November 14th. I'm not going to need much time to necessarily look at that and grasp the issues. So when's my next Tuesday? 3? No.
Oh, Tuesday, sorry. December 2nd.
That's my next day.
I'm sorry, November 18th.
November 18th. I can, if that gets in by Friday, then I can look at it and be able to deal with it over the weekend. All right. So what I will do is to move this along, I'll need the answer to the motion by the 14th, and then I will set it for a hearing on the motion and a pretrial for November 18th. That's an in-person hearing. That's a Tuesday, and that will be at 9 a.m. And then I'll hear argument on it and then we'll see whether we go forward.
Thank you, Your Honor. Judge, I'm sorry, Your Honor.
Yeah.
One housekeeping matter. I will note that Mr. Phan filed a complaint against Mr. Ridings in a separate matter. Is that it's case number 254C1603. It looks like it was a pro se filing. Is the court going to address that in due course, or is that something that we would consolidate?
My short answer would be no, but you have it?
I do. That was filed as a general civil matter.
So it's before Judge Barr.
Correct.
Okay. When was that? When was it filed?
It was filed on September 29th.
As the hearing ends, Judge Simpson sets a new date, ensuring every motion gets its due. The courtroom quiets, and even the out-of-state student earns a smile from the bench. Justice here isn't about who argues loudest, it's about patience, clarity, and giving everyone their fair day in court.
All right. Okay. Thank you, folks.
Thank you so much.
Thank you, Your Honor.
Take care. Seattle, have a good weekend.
We'll try.